Issues at hand.
Well, good morning once again and welcome to Issues at Hand. This is, of course, Wednesday, and we are discussing something to do with letters of administration. How do you apply for the letters of administration? What are the letters of administration? And, of course, what someone has to go through to get a death certificate, because I think that is one of the very pertinent issues that very many people don't even know that a death certificate exists. Those who know that it exists, they don't know the procedure you go through to get one, and why is it even important? Because some people don't find a reason as to why they should even apply for a death certificate. But that and more is what we are going to discuss in today's Issues at Hand. With us is Wandera David, who is a legal officer from the Judicial Service Commission. And of course, it's a pleasure having you this morning with us here.
Thank you very much. Good morning. Good morning, viewers of Family TV. I'm very happy to be here, and it's a pleasure. I expect a very good conversation today.
We are also excited to hear from you. And of course, starting up with the institution where you come from, the Judicial Service Commission. Some of us think that the sole reason as to why it exists is to give jobs to maybe the judges and the magistrates. But someone would really want to understand more about the Judicial Service Commission and what your jurisdiction is.
Yes, thank you very much for that question. So once again, I'm David Wandera, a legal officer from the Judicial Service Commission. And like he has asked what the Judicial Service Commission is, the Judicial Service Commission is one of the institutions that is created by the Constitution of the Republic of Uganda and has a special mandate which is also provided by the Constitution of the Republic of Uganda. One of those roles or mandate is the one that you have mentioned, which is appointment of judicial officers. Besides judicial officers, the Judicial Service Commission also appoints or recruits all the other staff of the judiciary. So the court clerks, the process servers, and all those other people working in court are all recruited by the Judicial Service Commission. But we don't end at only recruiting. We also go ahead and discipline. So if someone had a complaint against any of those people, they're also supposed to report to the Judicial Service Commission, and those complaints are processed and the remedy is given. The other thing which people don't know about is that the Judicial Service Commission also prepares programs to educate the public on the law and administration of justice, like we are doing today, and we actually appreciate Family TV for giving us this opportunity. Then the other one that we do is we do research to advise the government generally on the law and administration of justice. So everything that is to do with the judiciary appointment, discipline, and all advice to do with justice is done by the Judicial Service Commission. One may be outside there and maybe is hearing about us for the first time, and maybe they would want to reach out to us and get some of these services, because our services are free of charge. Some people don't know that. You can reach us on our telephone lines. We have a toll-free line where you don't have to have airtime to call. It's 0800 100 221 or 0800 100 222. Currently, our physical offices at Kingdom Kampala, 8th floor. So if you need our services, please feel free to reach out to us.
Okay, that is interesting that you do broadly this. I mean, but we are excited. So we want to get back to our point of discussion today, and we want to look at letters of administration. But someone would really, before someone gets into a challenge, they might never know what something is. So, of course, we commonly talk about letters of administration. We also talk about an administrator, but it doesn't sometimes come closer to someone until they are into the same mess. But we start with who an administrator is, and then we get to what the letters of administration are.
Okay, thank you very much. So letters of administration, or who an administrator is, are all related to, they go back to death of a person. So this is authority which is being given to manage that estate of that person who has passed on. This is a very important topic because it touches everyone at a certain point. At one time you will lose a brother, at one time you will lose a sister or a father or mother, and they will leave behind an estate that will have to be managed. So an administrator let me start by, is someone who has been granted authority by a court, a competent court, to manage the estate of someone who has passed on intestate. Intestate is someone who did not leave a will behind or did not write a valid will. Yes. So if someone dies and they don't leave a valid will, there will be someone called an administrator who will have to be appointed and given authority by a competent court to manage that person's estate.
So when you talk about a competent court,
Yes.
that also confuses. Someone would ask, is there an incompetent court?
Yes. Yeah, what I mean by competent court
Yes.
is that a court, before a court issues a remedy, it has to have what they call jurisdiction or the power to issue that remedy. To just give us a general picture, for instance, if someone's estate, the value is above 50 million, such an estate is supposed to be handled by the High Court where a judge sits. So if you took such an estate or such a case to a Chief Magistrate's Court or a Grade 1 court and they issue a remedy, that remedy will not be valid in law because that court is not competent or has no jurisdiction to grant that remedy. Yes.
Now it is clear.
Yes.
Now it is clear.
Yes. So if the estate, if the estate is below 50 million, it will have to be handled by a magistrate's court. If it's above 50 million, it will have to be handled by a high court. Yes.
Well, still as we are talking about so meaning it is now this court that issues that letter of administration.
Yes, letters of administration are only issued by a court. There is no other institution or no other person who has the authority or powers to issue letters of administration.
There used to be, I don't know, but as I was growing up, there was something I used to hear where people were always going to the Registrar General. What were they always going to do there? I think that it was URSB.
Yes. Before, there used to be certificates of succession that they used to get from there, especially for issues of land. Yes, but now the process has been aligned in the law. It's very clear both in the Administrator General's Act and Succession Act. So before you get letters of administration, you'll have to go through the office of the Administrator General. Only that through the Administrator General, you'll be seeking another document which is called a certificate of no objection. The Administrator General will be saying that they do not object to this particular person managing that estate.
Now that takes us to the process of obtaining or applying for the letters of administration, because now if you say that this is part of the process, now we get to the entire process.
Yes.
Where does it all start from?
There are three major steps that we shall look out for in our discussion. The first one is application of a death certificate. So when someone passes on, there's supposed to be a death certificate. The second step is that one that we have just talked about briefly, is that person who is going to apply or to be granted that authority has to also get a certificate of no objection from the Administrator General. And then the last step is petitioning the court. Like we said, it's only court which will grant you the letters of administration. However, those authorities, if you went to Administrator General without a death certificate, they will have to send you back for a death certificate. If you skipped, for instance, the second one of certificate of no objection and went to court without a certificate of no objection, they will send you back for a certificate of no objection. So all those steps are crucial and they all have to be fulfilled before someone gets the letters of administration finally.
Now, we start with the death certificate. Where is it obtained? How do you apply for it? Why is it even? Why should people make it? With Ugandans, it's not something we always. Until you got into a space where you need it, that is when you will now start darting here and there looking for it. But we start with that a death certificate. What is it, and how do you apply for it, and from where?
Yes. So we all know in Uganda there is an institution that does registration of all people in Uganda. Most of us know it because of national IDs, that every Ugandan is supposed to have a national ID. Likewise, when someone is produced, they're supposed to have a birth certificate. So it's mandatory to have a birth certificate. It's mandatory to register and have a national ID. It's also mandatory if someone passes on to register that death.
Hey.
Yes. So the government or that particular institution, NIRA, has to be knowing who has been born today, who has died, how many people do we have in Uganda, who is registered as a citizen of Uganda. So registration of death is compulsory, it's mandatory, and the law says it's supposed to be done within 3 months of the death. Yes, but like we said, besides the government knowing those statistics, you will not reach the second step in this application for the letters of administration if you don't have a death certificate, because it's the only thing that you will need to prove that a certain person passed on. Yes, even when you go to court, for instance,
Does it also look like a birth certificate?
Yes, yes.
Okay.
It's also, if you've seen the birth certificate, it also looks like it's that long form like a birth certificate, only that has details of death and it has a heading of death certificate. Yes, so how does one apply for this death certificate? If someone passes on, usually people pass on from home or from hospitals. So when someone passes on, it's important to get, they will issue you with a form detailing that this person has died at the hospital. There's no hospital where you die and just take away body before they have given you a form certifying that this person was being managed at their hospital and passed on, and they give the date on which that person has passed on, and also give the reasons why that person has passed on.
And some of us think that is the death certificate, and that is what we present.
Yes, some people end at that and think it's the death certificate. That is not the death certificate. That is just one of the documents you're going to need while applying for the death certificate. The death certificate is only issued by NIRA.
Okay.
There's no other institution that issues the death certificate. So that's one of the ways you may get that first form detailing the death. The other one...
So what happens if someone dies from home and they didn't die from hospital?
Yeah, when you pass on from home, it's important that you report this death to the authorities in the area. So when you report to the authorities in the area, it could be the sub-county chief or the LCs, report that death. Those people, the authorities in that area will also issue you with a form. At least most of you have seen it as well. When you report that death to the authorities, they'll write for you and say so and so has been known as a resident of this area and has passed on due to such and such a reason on such and such a day. Yeah, so make sure when they write for you that form, they stamp on it as well and sign it duly. So that is the first thing you're going to get. Take that form then to NIRA, the nearest NIRA officers to you, and report and say, I've come to report a death and seek a death certificate. At NIRA, they'll help you process a Form 12, which is for reporting deaths. It's in the law. They'll help you process that form. That form basically has, you have to fill in the name of that person who has died, their date of birth, their NIN number, national identification number, their cause of death, where they were staying, and those are the details that they are going to record at NIRA. You record them in a certain form, and on that form, you'll also have to record your details, you, the person who is reporting the death, your details, and your relationship to this person whose death you're reporting. At the end of that form, there's a certification of you saying that you know that the information you're providing is true to the best of your knowledge. When you finish filling that form...
I look at a situation while filling that form, and I don't know that this is this NIN, and neither can I access their national ID. Maybe it got lost at some point, and so I cannot really get their NIN. What happens in that?
They'll note that on the form, and usually if they issue the death certificate, sometimes they can, if you have the name of a person, because they will have the record, if that person was registered, they can trace it. If they can't, then that will be noted on the death certificate as well. Yes.
Okay.
So when you finish that, you'll have to pay a fee. It's about 20,000 in the bank, or sometimes you can generate the PRN. If you've done online transactions for URA, you generate the PRN, pay the fees, attach all those documents on that Form 12 which you shall have filled at the NIRA offices, and then they'll give you a tracking number to follow up and come and pick the death certificate. Usually it will take about 1 to 2 weeks Yes.
Why does it take that long? I realize that these days NIRA has made, especially with the national, with the birth certificate, so easy that you apply and go with your ID. Can't they also have an express, and then they have an express of issuing this? Why does it have to go through another process now?
No, the 1 to 2 weeks I'm giving is a maximum of the time within which you're going to get it. Yes, but you'll be given a tracking number. Depending on how many applications they have, you could get it immediately, you could get it in 2 days or 3 days or a week, but in 1 or 2 weeks, you'll have gotten your death certificate. Yes.
Now I have the death certificate with me. You told us that is the first step.
Yes.
Now the next step is going to the Registrar General.
Administrator General.
Administrator General,
Yes.
To get a letter of no objection.
Yes.
So how do I apply for this? Do I just go there with my death certificate and I present it and I tell man, I need this letter? Or what happens when I'm there?
Yes. If the form that you're supposed to fill again at the Administrator General,
there's another
is
form
going
again
to be found in the file at the Administrator General. Yes, because at the Administrator General, the details they are going to need from you are different from the ones they needed from NIRA. NIRA, they are only confirming that this person has died. At the Administrator General, there are issues now of property going to come in, for instance. And at NIRA, they are not concerned about the estate and who is going to manage it. At the Administrator General, they are concerned about the estate. How many children did you leave behind? How many widows, if any, did you leave behind? What property did you leave behind? Where is it located? And things like that. So Administrator General, you will again need to fill another form detailing your name, for instance, the name of the deceased person, the date they died, where they were residing before they died. Did they have any children? Did they have any property? Did they have a widow? And details like that. So when they fill in those, they'll open for you a file which will be put in the names of that person who passed on, the estate of so and so. When the Administrator General finishes filling, of course, you'll have to have the death certificate as well. Like I said, you cannot start that process without the death certificate. They'll ask you to go and get it. So when they fill in that and open for you a file, the Administrator General will have to call a meeting himself with the family of the deceased person. Yes. Because someone could come from the family of that deceased person and report and say, I'm the one the family has chosen to be the administrator. And yet the family doesn't even know about that person. Because that person maybe is being fraudulent, they're interested in maybe stealing the property, they go or at the back of the family, or they mention some children and leave out some children. So issues like that. The Administrator General will call his own meeting personally, sit down with this family, and then iron out those issues and make sure whatever is reported is what the whole family is reporting or knows about.
Okay.
Is there a widow? Yes. How many? Were they illegally married? Are there children? How many? Are there any who are deceased? Did they leave any children behind? Were there properties? Where are these properties located? Has the family chosen someone to be an administrator or people to be administrators? If yes, do all the children or all the beneficiaries agree or consent to this particular person being the administrator? So all those details will be ironed out by the Administrator General. They will write minutes for that meeting, and they will have to attach the signatures and passport photos of all the people who have attended that meeting. That meeting has to be attended by all the beneficiaries. If you don't inform any of the beneficiaries and they don't attend that meeting, then when you go to court, those letters of yours can be challenged by any person. If it was, for instance, one of the children and they never invited for this meeting, they don't know what transpired at Administrator General, they didn't consent to someone to be an administrator, and they raise it in court, court will send you back to Administrator General.
Well, we are taking a short commercial break, but when we return, now we are coming back to continue with this conversation. Now we realize things are more serious than what we thought, but also I think the biggest interest is in who identifies these people, because I also see something might come up within the process. Anyway, we are coming back shortly. Stick with us.
Issues at hand. This is Church of Uganda Family TV. Enriching lives. Regulated by the Uganda Communications Commission. This is Church of Uganda Family TV. Enriching lives. Regulated by the Uganda Communications Commission. Issues at hand.
Welcome back from the break. We are looking at letters of administration, how you apply for them. We are looking at the entire process. We started with the first process, that is obtaining the death certificate. And of course, it is NERA that issues this death certificate. Now, from the death certificate, the next thing is applying for the letter of no objection, and this is done by the administrator. This is issued by the administrator general, and we are looking at the process. Now, before the break, you would say that the administrator general convenes a meeting of the family members. But I look at a situation, does the administrator general dictate on who should come in that meeting, or whoever you find? For example, you tell us to come with the family members, whoever I find deemed important for that meeting is the one I invite. Who specifically invites this meeting? And who chooses the people to be part of this meeting? Because, our families have a lot of issues, families have a lot of wrangles. So they will say, we shall not invite the other one because of this reason, we shall not invite the other one, they might sabotage this. So who dictates? And there are specific people that should be part of that meeting.
Well, the meeting is called, like I said, by the Administrator General, but the Administrator General may not be the one to come sometimes to convene that meeting. Sometimes they sometimes they delegate to the town clerk of the area. But usually they copy in that meeting or the letter, that invitation, the LC chairperson. Usually the LC chairpersons know the family of that person, the closest family, those who have been with him. So the LC is also copied, and they usually attend that meeting to make sure everyone is around. But like I said, even if you leave out certain people, if those people ever find out that you're applying, sometimes even when you've applied and you've been granted letters of administration, like we shall share later, that person can challenge that whole process, and court can revoke or cancel those letters of administration. So it's for your own good as a family to make sure everyone is around and to make sure everyone consents to whatever you're discussing. That smoothens the process. Otherwise, when you leave out certain people for certain reasons, then those people can challenge those letters and they will make the process lengthy for you. Yes.
Now, of course, after the meeting is done. The family meeting. What happens after? You told us that the minutes are taken, signatures and passport photos. Why are passport photos important?
Passport photos are to make sure, like I said, these documents after that are going to court. So they are to make sure that the person who has been brought as David Wandera, as the firstborn or the son of the deceased, is actually David Wandera. Because later on, court does identification, like we shall share later, to make sure that the David Wandera is David Wandera, the person X, the Kizito is Kizito, the Namukwaya is Namukwaya. So everyone has to provide their passport photos and their national IDs and signatures. All that is to make sure that this business that is being done in transparency, and all the children or everyone supposed to benefit is involved in the process and they know what is going on. Yes.
So is this meeting supposed to be one, or there are alternative meetings that are always called upon, like 4 or 5, or in that one meeting that is enough to obtain all the information that the Administrator General needs to issue the letter of no objection?
Yeah, one meeting is enough, but they can do more than one meeting. There are times when they'll call you for a meeting, and then one of the essential people doesn't come for the meeting, but they have a genuine reason. The child was sitting exams, for instance, they're doing their UNEB or whatever it is, and they didn't show up.
Maybe they're sick.
Or they are sick, yes. Or so and so are traveled abroad at that time, but they're coming back on such a date. So they could meet and look at certain issues, and then they call another meeting to make sure this person is around and also acknowledges that whatever was discussed is true, and they also append their signature. Or they could postpone the meeting, the whole of it. And there are sometimes when they call meetings and the family is not agreeing on certain things. For instance, in the first meeting, they propose person A and B to be the administrators, but then a big majority of the family doesn't agree with those two people. You're saying, no, for us, we don't agree with so and so. And then in that meeting, you realize they don't reach consensus. Then they may give you more time to think about it and maybe propose better people. And maybe they adjourn the meeting and you meet another day until they agree on all the things that they're supposed to agree on.
Yes. Now, how long does it, after the meeting, how long does it take to get the letter of no objection?
It's usually, it depends again on how many files the Administrator General is working on, how many estates. It could also take a day when you finish the meeting. But usually when you finish the meeting, if it's the Administrator General who has come, they'll usually give you a date even there and say on such and such a day, you come and speak the letter of administration. But like I said, sometimes it's the town clerk who conducts this meeting. So still the Administrator General will communicate and say on such and such a day, you come and pick the certificate of no objection. Yes.
Now, I have the birth certificate, I have the letter of no objection, and what I'm left with is now applying for the letters of administration. Now we get to these letters of administration. How do I start the process, and which entity now issues? Okay, you told us it's court that issues letters, but how do I start? Because some people fear court. That's the reality. When people hear, you have to go to court, now people will pull out and say, and you'll find them having underground wrangles here and there, but they cannot even make it legal because they know when you go to court and the prominent saying, someone might come and maybe, infiltrate and then pay something, and then there's a lot that happens, and that it's the reason people fear court. So, but what is the process so that people's hearts can be calmed to know that no, this is different?
Before I go to that question, I just want to point out certain issues on certificate of no objection that people should take note of. For certificate of no objection, first of all, if you get it, it doesn't give you authority as an administrator. It's just one of the processes for you to reach the stage of administrator. So don't get certificate of no objection and start distributing property or be committing a crime. Number two, certificate of no objection. When at that stage of choosing who should be an administrator, priority is given to the widow or the widower, the surviving spouse. They make sure that person is the administrator, and others, if you want other people, or that person only, but they're usually given priority.
How many should the administrators be?
There is no limit. There is no limit.
Okay.
Yes. But it's good, of course, to get fewer people, because usually there are documents which they will need to sign. And if they want to sign one document and you've put 10 people as administrators, one of them is not around, so you'll not have to process that. So the fewer, the better. The other thing on certificate of no objection is that it may not be needed, or it's not actually needed, where the estate is below 50 million shillings. You skip that step. You don't have to go through Administrator General.
Why?
Where the estate is below 50 million, you go straight to the court, and the court will process it for you.
So the moment you have a death certificate, you only go to court?
You petition, yes, like the process we are going to discuss after. You go straight to court.
Why? Why is it like that?
These are small estates. Usually they don't have a lot of issues. They usually don't have a lot of issues. They are small. They are actually called small estates in law. So they don't actually usually have a lot of issues. That one you go straight to the court, and that's why they're handled by the magistrate's court, not the high court. The other issue that I wanted to point out on letters of administration, they are also not necessary where someone left a valid will. If someone left a will, it's valid in law. There are witnesses, there are executors in the will. The executors are there and they are willing to administer this estate. You don't have to again go to Administrator General. You also go straight to court for the probate.
So, so because the will is clear, it sets everything clear.
Yes, you are not going to choose. There's not going to be those issues of choosing who is going to be the administrator, because the will has an executor who the person who died preferred to be the one to manage their estate. So you don't have to go to the Administrator General.
Okay.
Yes. So let's go to.
Now the application.
The application,
of the letters.
Or the petition for the letters. Yes. This is supposed to be done in court. Only court grants letters of administration. Like we said, the court is supposed to be competent. While we're introducing, we said if the estate is above 50 million and above the value of the property or the estate, you go to the High Court. Right now in Kampala, there's a family division of the High Court, so that's the court you go to. You don't go to the criminal division, you don't go to the land division, you don't go to the civil division or the other divisions. You go to the family court. In other places where the High Court statutes, you go to the High Court. The High Court usually handles all issues. Where the estate is below 50 million, the value of the estate, you go to the magistrate's court. So it's the magistrate that issues those letters. So in the court, you're supposed to have a document that is called a petition. The petition usually has the names of the names of the deceased person, the names of the person who is applying, their relationship to the deceased, where was this deceased person residing, did they leave property behind, did they leave children, things like that. Did you get a death certificate? Yes, attach it. When did you get it? Did you get a certificate of no objection? Yes, when? And attach it to that petition. And then that petition, you'll also have to swear it before a commissioner for oaths to certify that whatever you're saying above there is true and correct to the best of your knowledge. So there will be a commissioner to also certify and commission at the end of that petition and stamp with their stamp for commissioner for oaths, saying that you've proved that what you're saying is true. When you take that document to court, you'll be required to pay a court fee. It's about 6,000 shillings only. Yes. You'll be guided at the court, though. You'll find someone who will guide you. You pay that money only in the bank. You don't pay it to the court staff. They will issue you with a receipt. That general receipt is the one you provide to the court. When you file that petition in court and you've attached everything that is supposed to be attached there onto the properties, the evidence for properties, their certificates of title, then you should be able to attach those certificates of title. If there are agreements, you should be able to attach those agreements. You attach the death certificate, attach the certificate of no objections. If there are minutes for meetings that you've had as a family, attach those minutes and the signatures and all that. Then the court will help and guide you and process for you an advertisement or a notice for you to run in the newspapers. If you have seen newspapers nowadays, on that page for advertisement, you'll see certificate of no, people applying for letters of administration, petition for letters of administration. So that message that court does is put across to the public, and usually if you read that message, court is saying, so and so has petitioned for letters of administration for the estate of so and so. We are going to go ahead and grant this person those letters if no one objects within 14 days. So that advert runs for 14 days in a newspaper of wide circulation. Court is giving the family or the beneficiaries another opportunity in case there's someone who is disputing these particular people to be the administrators, or they don't agree with the process, or they skipped a certain process while applying, or they're not invited in one of these meetings. Court is giving you an opportunity to object before they grant these letters of administration. So that advert will run again for 14 days. Now court has even insisted that while you're applying, you're supposed to attach your passport photos again, you the people who are applying, and the photo of the deceased person, so that we know who is this deceased person you are applying for. Because sometimes people change something in the name or put a certain name that maybe some family members didn't know about. Wandera David Derrick and Swandera David. And yet they're applying for the estate of this particular person. So even if someone saw this advert, they don't know that this is the person they apply. So court makes sure that they attach even the picture. Nowadays, if you see those advertisements, they have the picture of the people applying, the picture of the deceased. If those 14 days expire, after court has given you that, they have registered your file at the court, you've run that advertisement in the newspapers, those 14 days have expired, no one has objected. Then, or put a caveat on the application, then court will invite the people who have applied for those letters of administration for a meeting at court, which they usually call an identification meeting. In that meeting, court is also now taking it upon themselves to make sure that this Wandera David who is applying for letters of administration is actually Wandera David, and is actually the person who was chosen by the family of the deceased person, and that they know about the estate of this deceased person. So court will nowadays, before they used to only call the petitioners this person, this particular one or two people or three people who apply. Nowadays court calls even the other family members for this identification to still certify that this person who is applying for the letters of administration is the one who was chosen by the family. So if this person is identified, they are interviewed and they know about the estate, they know the properties, they know the children, they know their duties, then court will go ahead and issue this person with letters of administration. They will again not issue them to you straight away. They'll give you a date to come back. And then you pick your letters of administration from the court. And they will usually give you even a certified copy of the same. They'll give you the original and certified copies for you to do other businesses in the estate. Yes. It's only after you getting those letters of administration that you now become an administrator, that you get the authority to administer this estate.
Now I have the letters of administration. I'm now an administrator. What are the roles and duties of an administrator? Because, we casually talk about an administrator, an estate administrator, but what are the duties of an administrator? And at what point does someone cease to be an administrator?
That's a very good one. Because some people get these letters and assume when you've been given letters of administration, then all the property is now yours. Then
you can sell it at your will.
Enjoy, yes, the sweat of the deceased person. Yeah, so that's not true. Letters of administration, if you're given letters of administration, you're only given the authority to manage this estate on behalf of the beneficiaries. So number one duty is distribution of property to the beneficiaries according to the law, of course. Number two is you're supposed to file an inventory in the court. In 6 months, inventory is a document you file to court saying, since you gave me letters of administration and I started administering, I found that this person actually has these properties here and here and here. I found that this person had some credits or was demanding so and so and so money, or had money in the bank, which we need to get. I found out that this person also had debts, to pay so and so and so and so. So your court is supposed to be knowing whatever is transpiring, whatever you found out. The other thing you're supposed to do is file accounts. Accounts are now supposed to be done in 1 year. That after 1 year, you inform court that since the last time when I informed you in the inventory about this and this and this, I've now gone ahead and distributed this to so and so. I've distributed this to so and so. I've paid this debt to so and so, and this one to so and so, and I've picked this money from the bank and this and this. So you're telling court what you've done in the estate. That is the duty of the administrator in the estate. The other question you asked was, do these letters of administration expire?
And when does someone cease to be an administrator?
When they cease to be an administrator.
We start with expiry. Do they expire?
The letters of administration expire. Before, it was open and people would have letters of administration forever, and they're not doing anything in the estate. The children sometimes of the deceased maybe were going to school, they are suffering to get school fees, and this person has letters of administration sitting on them because they're done with authority. Now the letters of administration expire in 2 years. So in 2 years, the administrator should have done everything they're supposed to do and report back to court in those timelines I said. So that's one of the ways the letters of administration expire, after the administrator distributing the estate and filing the inventory and account in court. The other way is those letters of administration can be revoked by the court for certain reasons. If someone petitions and says, I was not invited, like we said while discussing, I was not invited for these meetings, those letters of administration will again be cancelled by court. If court finds out that you got those letters fraudulently, or if court finds that you didn't file the inventory or you didn't file the accounts, those letters of administration can be cancelled. So they will cease to exist or to give you an authority to manage that estate.
Okay. Now, as we wind up in the remaining minutes, this is now very pertinent, and I believe even someone watching us would really want to hear who is entitled to benefit from such an estate where the deceased did not leave a will, and how much can they benefit? Yeah,
that is a very important question. So there are people called beneficiaries in the estate. One will wonder who are the beneficiaries. The first person supposed to benefit is the widow or the surviving spouse of that person who died. So it could be the widow or the widower. The other people are the children.
Well, when we talk about the surviving spouse, because they tell us in law, as long as you're not legally married, you're not considered a wife or a husband. So does court now consider you as a surviving spouse?
No, all these processes that we're saying, right from Administrator General and saying they called this meeting to find if there were any spouses and all that. If at the meeting of the Administrator General they discover that, yes, you had children with this man, but you're not legally married in one of the marriages that are recognized in Uganda, then you will not be registered anywhere as a surviving spouse. So even up to the stage of court, up to the stage of distribution, you will not be considered as a surviving spouse. So it's only someone who was legally married to this person that will be considered. Yes, so that's the first person or first category of people who are going to benefit. The second is the children. The children is any child of this person. It doesn't have to be the one who is a child of this surviving spouse. There are men nowadays in our African cultures who have, yes, this person they are married to, but then they have children from elsewhere. So all these other children are also considered as this person's children, whether legitimate or illegitimate. So all these children will have to benefit equally. The other thing that people should note is whether male or female. In some of our cultures that we are doing away with is some people say women or girl children do not benefit from the estate of their father. So the law dictates and says all children, so whether male or female, whether girl or boy, are supposed to benefit. The other people are dependents. People have been depending on this person. They may not be children necessarily. Maybe it's a parent, it's an old parent who has been in this person's home for, 10 years or 5 years, and all their benefit that or survivorship has been through this person. Those people will also benefit in that estate. Yes, and then the heir. In our culture, we have heirs who are considered when someone passes on. So the heir also benefits in the estate. I'll give just the breakdown of the where all those people are present. If there is an heir, there is a widow or widower, their children and their dependents. The widower or widow will be entitled to 20% of that estate. The children will be entitled to 75%. Or lineal descendants of that estate, and they share it among themselves equally. 4% will be reserved for dependents. People have been depending on this person, but they may not necessarily be children. And then 1% always is given to that heir.
Why?
Yes. Because heirs, our laws also are entrenched in our cultures. So the law, where there's succession, the law doesn't want to do away with the heir completely, because those people are considered in our customs and culture.
I look at the heir being given just little, very little, yet they're the ones, and you know they're almost inheriting the entire problems, because the children will come to they'll get back for school fees. I mean, and all those details.
That is a very important issue now that you've raised. Where there are children who are going to school, the law has also put in place that if their children who are going to school, before all these people get shares, 20% of the estate shall be taken away for young children who are going to school. Before they share now the other 80%. In those other categories I've shared, so 20% will be taken away for who? The children who are going to school. The disabled, someone may be disabled and they are not married, and they have been depending on this person who has been who has passed on, or even if someone is above 18 years but they are below 25 years and they are going to school and they are not married, that 20% will also be reserved for them to benefit for their studies and all that as they prepare for their own future.
Well, David, I see our time is fast spent, but kindly give us your closing remarks as we wind up with this discussion. I know we shall get some more time and discuss this more and more, because I think we need to make it very common to people so that they normalize with some of these things to avoid very many issues that arise, especially when someone dies. But give us your closing remarks for today.
Thank you very much for hosting me. Thank you to Family TV for giving us this opportunity. And I only want to remind people that the institution where I'm coming from, Judicial Service Commission, offers free legal services, and people should feel free to reach out to us in case you want to learn anything about the law, in case you want to ask any question, in case you want to talk to a lawyer. You reach out to us on our lines that we have shared, which is 0800 100 221 or 0800 100 222, or you can reach out to us at our offices physically at Kingdom, Kampala. Thank you very much.
We really appreciate, and thank you so much to you, our viewer. We've come to the end of today's Issues at Hand. Wow, it was such insightful, and a lot. We've left out a lot because of time, but I believe we shall find more time and discuss this in depth. Of course, for now, I've worked with Liz, of course, SC, who we started with way back, Mumuza, and Patience. From the entire team, we wish you a blessed day.
Issues at Hand. This is Church of Uganda Family TV.